Thank you, Madam Chairman. Mr. Nunes Neto, I noticed that in your testimony began, Mr. Guest followed up, and Ms. Mandrala's testimony also began with making clear that that you disapprove the policy behind MPP. Do you, of what relevance is that? You would agree with me, wouldn't you, that if you've got an obligation under law, that you have to perform the obligation under law without regard to whether you like it or not? Isn't that true?
That is true, sir, and we are, as I've noted, complying in good faith with the court order, and we believe very much in the rule of law.
Yeah, but you didn't answer my question. Of what relevance is it, and why do you start off your statement by making clear that you disapprove the law that you're required by court to follow?
We disapprove of this program, and the president and the secretary have made quite clear that MPP is not aligned with this administration's values and actually distracts from some of the important priorities that we have that we believe will have a similar effect on reducing border flow, sir.
So now you've repeated your preference, but again, my question is, you're supposed to be carrying out the law. The Constitution requires you faithfully to execute the law. So my question is not why you believe, not why your preferences are what your preferences are, but why do you start your testimony before this committee concerning compliance with MPP, compliance with the court's order? Why do you begin it by telling us what your preferences are?
Sir, we believe the law supports our position that the secretary has the authority to terminate MPP, and we are committed to fighting the court's order all the way up to the Supreme Court if needed, and have done so already and will continue to do so, and are looking forward to the arguments before the Supreme Court, which will happen in April.
Would it be, but that doesn't change the fact of what your legal duty is now, does it, sir? You're under obligation by order of a court. In fact, the United States Supreme Court has declined to grant a stay from that order, right?
That is correct, sir, and that is why we have moved forward with implementation and are re-implementing in good faith with the court's order.
Would it be possible to sabotage a policy with which you disagree, even while professing that you are proceeding in good faith to execute it?
All I can say to that, sir, is that we are committed to implementing in good faith. We have worked round the clock, many thousands of hours across the U.S. government to re-implement this program that we disagree with. And we are committed to continuing to comply in good faith and continue to increase enrollments even as we fight this court order.
And yet we have the sheer data that indicates that given the level of illegal migration at the border, almost none of the persons being encountered are being put into MPP. Mr. Huffman, I'd like to ask you, I noted that that the as being implemented, if there's people will be disqualified from MPP or not put into MPP if they have a physical or mental issue or some other disability, but a physical or mental issue. What would prevent lawyers that are furnished to prospective enrollees from coaching them to say that they're depressed or have anxiety? Would that then, if they then repeated that to a CBP agent, would that keep them from going into MPP?
Certainly. Thank you for the question and for that. So not really having privy to what their consultation with the attorneys are, but certainly that people have been enrolled and then disenrolled when vulnerabilities were found out at a later time. How they arrived at those vulnerabilities or how they became, I don't really have insight into, but the scenario you described, I guess is certainly possible.
So well, then what are the prophylactic devices or prophylactic measures to make sure you're not susceptible to just fraudulent manufacturing of evidence or indications like that to keep somebody from being enrolled in MPP?
Sir, we try to focus on those when we're deciding who's going to be the best suitable candidate to be enrolled into the program would be least likely to have any vulnerabilities that would show up at a later date. Because for us to enroll someone and then have to disenroll them it takes time, operational time away from the work. So we focus on those that we're confident we have a high likelihood to get through the program and not become vulnerable or declared vulnerable at a later date.
So I don't hear any protection for that whatsoever, which to me it sort of gives the lie to the entire notion of a good faith compliance. If you start off your statement by saying you don't want to, you despise the program, you note your obligatory obligation to faithfully, to execute in good faith, and just pose one notion to the courageous CBP right there. There's no defense for that. You can just evade it at will. And that's what I think is happening. So I yield back.